and welcome to the 14th meeting of this committee in 2020. Our public business is an evidence session on the judicial review phase of our inquiry. Can I remind all those present and watching that we are bound by the terms of our remit and the relevant court orders, including the need to avoid contempt of court by identifying certain individuals, including through jigsaw identification. The committee as a whole has also agreed that it is not our role to revisit events that were a focus of the trial that could be seen to constitute a rerun of the criminal trial. Our remit is clear, and it is to consider and report on the actions of the First Minister, Scottish Government officials and special advisers in dealing with complaints about Alex Salmond, former First Minister, considered under the Scottish Government's handling of harassment complaints involving current or former ministers and procedures and actions in relation to the Scottish Ministerial Code. The more we get into specifics of evidence, that would be time, people, cases, the more we run the risk of identifying those who made complaints. The more we ask about specific matters covered in the trial, including events explored in the trial, the more we run the risk of rerunning that trial. Wherever possible, can witnesses, as well as members, please avoid discussion of the specifics of concerns or complaints and also avoid naming specific government officials under senior civil service level. Can members please ensure when asking a question on a particular government record that they give the document reference and also the footnote reference to the government witness for their ease of reference. The committee therefore expects a full account today, and where legal privilege is asserted on any details, we would appreciate the grounds for this to be set out clearly. With that, can I welcome the Lord Advocate, the Right Honourable James Wolfe QC, and begin by inviting the Lord Advocate to take the solemn affirmation. Lord Advocate, would you please raise your right hand and repeat after me? I solemnly, sincerely and truly declare and affirm that I will tell the truth, the whole truth and nothing but the truth.
I solemnly, sincerely and truly affirm that I will tell the truth, the whole truth and nothing but the truth.
Thank you. I now invite the Lord Advocate to make a brief opening statement of up to 3 minutes.
Yes, thank you, Convener. When I last attended a meeting of this committee, I described the constitutional and legal framework within which I give my evidence. That framework includes the principle of collective responsibility, the principle that in general ministers and not officials are accountable for the actions of government, the Law Officer Convention and legal professional privilege. In relation to legal professional privilege, I am of course aware of the debate in the Parliament on 4th November. The Deputy First Minister has written to the committee advising it that the government is considering the implications of the motion consistent with the Minister's obligations under the Ministerial Code, and he stated his aim to update Parliament as soon as possible. The committee will appreciate that it would not be appropriate for me to preempt the outcome of that process. That will not prevent me from giving evidence to the committee today about the government's legal position from time to time in relation to the judicial review. And I thought it would be helpful by way of introduction to this session if I briefly describe the evolution of that position. The petition, served at the end of August 2018, contained a wide-ranging attack on the procedure and its application on a number of grounds, including fundamental attacks on the lawfulness of the procedure itself. The government addressed those grounds and was satisfied that all of them could and should be resisted. The government's position on those grounds is set out in its pleadings. At the end of October 2018, the contact between the investigating officer and the complainants was identified by the government as a matter which required to be addressed. Investigation of that issue resulted in both parties adjusting their pleadings to make averments about that contact and in the voluntary production of documents by the government. The government made factual averments about the matter on the 5th of November, and it was introduced into the petitioner's case as a specific ground of challenge in mid-November. Adjustment of the pleadings continued into December. The government was satisfied at that stage that it could properly continue to defend the case and that the matter should be argued in and determined by the court. That decision was fully informed by a consideration of the legal position. In particular, the government's position was that paragraph 10 of the procedure was directed at prior involvement of the investigating officer with the matters being complained about, such that the contact between the investigating officer and the complainers in this case was not a breach of the procedure. And whilst the government recognised that the procedure was open to an alternative reading, it considered that the arguments could properly be advanced in favour of its interpretation and that the issue should be put before the court for determination. And on the factual information available at that stage, the government concluded that it could properly defend the allegation of apparent bias. The voluntary production of documents by government led to calls for further documents, and on 14th December, the court approved a specification of documents which resulted in a commission for recovery of documents. On 19th December, during the commission process, 2 documents were produced which disclosed contacts between the investigating officer and the complainers, which had not previously been identified. As the committee is aware, the production of those documents led to a review of the case and to the conclusion on 2nd January 2019 that the petition should be conceded. I look forward to discussing these matters further with the committee.
Thank you, Lord Advocate. The committee has many questions for you, and we'll start with Maureen Watt.
Thank you, Convener. Good morning, Lord Advocate. Can I first of all ask you at what point you were first involved in the judicial review, and what was your role in relation to the judicial review, and if you were involved in any of the meetings around the judicial review in the time frame that you gave from the 31st of August to the 8th of January. And if you weren't involved in the meetings, were you updated at regular intervals?
Yes. As the committee is aware from both my initial letter and my previous evidence, ministers do not confirm the involvement or non-involvement of law officers in any particular matter, and I've explained the basis for that approach to the committee. The corollary, of course, is that I appear before the committee and accept responsibility to account to the committee for the government's legal position, regardless of which lawyer or lawyers were involved in any particular aspect, and in particular regardless of whether either of the law officers was or was not personally involved.
So are you saying that you're not prepared to tell the committee whether you had a kind of hands-on involvement in all the legal work that we've heard was going on frantically among the Scottish Government Legal Department in relation to this?
As I've explained to the committee before, ministers, when they appear before Parliament, appear before committees, respect the Law Officer Convention. That's part of the constitutional framework within which we operate. The consequence, effect of that convention is that we don't, ministers don't confirm the involvement or non-involvement of law officers in any particular matter. As I say, that doesn't imply in the least that I don't accept responsibility to account to the committee for the government's legal position. The Ministerial Code makes clear my responsibility in that regard. And the important point is, regardless of which lawyer or lawyers were directly involved, I'm here to answer the committee's questions.
Can you tell me then whether you were the only minister involved or not, and were other ministers kept fully informed of what SGLD were doing?
I am aware that other ministers were informed and involved. The precise detail of other ministerial involvement is, I'm afraid, not something I can give chapter and verse on today.
It's funny because we've already heard on evidence given to the committee on the 27th of October, and I quote, "I'm aware that the Lord Advocate was involved. I'm not aware of any other ministers being involved." And then on the 3rd of November, we heard that ministers were fully informed insofar as they got written briefings but were not given a commentary. Would you like to comment on that?
Well, I know that, for example, and I think it's apparent in information that the committee already has, that the First Minister was involved at certain stages. Precisely what nature and form the briefing provided to ministers and to the First Minister took at any particular point, I'm afraid I can't answer today.
Can you tell us then whether any external legal advice was sought and what the extent of that might have been?
Well, the committee will appreciate I won't go into the content of legal advice, but the committee is aware that the government instructed senior and junior counsel. The committee has information about the meetings which were attended by senior and junior counsel, and they were involved in providing advice throughout the process.
Okay, thank you, Convener.
Margaret Mitchell.
Good morning, Lord Advocate. I wonder, before we can start on my substantive question, if you could clear up something that was raised by me in evidence when the Permanent Secretary and yourself both appeared before the committee. I asked the Permanent Secretary, who informed the First Minister that the decision had been taken to refer complaints to the police. The Permanent Secretary suggested that it may well have been yourself that informed the First Minister. Can you confirm if that was the case?
Consistent with Law Officer Convention, I'm afraid I can't, Ms Mitchell. It wouldn't be appropriate for me as a minister to confirm or my involvement or non-involvement at any particular stage.
So something as simple and basic as, yes, I told the First Minister that a complaint had been made about the former First Minister to the police, you can't answer?
It wouldn't be consistent with Law Officer Convention to confirm the involvement or non-involvement of law officers at any particular stage in the process.
So can I also take it wouldn't be appropriate for you to confirm whether you had any contact with the police regarding the Scottish Government's handling of the harassment complaint?
It certainly wouldn't be, I don't think it would be consistent with Law Officer Convention for me to confirm or my involvement or non-involvement in the consideration of this matter by the government.
So these are questions that you will not answer today?
I'm not, as I say, I don't think it would be consistent with Law Officer Convention for me to answer those questions for the reasons that I've set out very fully in my initial letter to the committee and in the evidence session in September. As I say, that in no way prevents me from answering questions in whatever level of detail the committee would like about the government's legal position from time to time in relation to the judicial review, the procedure in relation to the judicial review, or the considerations that were, from a legal perspective, taken into account and were relevant in the context of the government's handling of the judicial review.
Right, well, perhaps for the avoidance of doubt, we can absolutely confirm the capacity in which you're appearing before the committee this morning. Is it as the principal legal advisor to the Scottish Government, member of the Scottish Parliament with collective responsibility, or in your role as the head of Scotland's Independent Crown Office and Procurator Fiscal Service?
Well, I'm the Lord Advocate at all times, and I have the range of functions that the Lord Advocate has at all times. Those include my independent responsibilities as head of the system of prosecution, and they include my responsibilities as the government's principal legal advisor.
So you're appearing in both capacities today?
Well, I'm the Lord Advocate. I can't, I can't escape the various capacities that go with that role, and nor would I wish to.
Well, I think there's a question there that has to be answered then, and that is, given this dual role and your advice to the committee and the fact that you are the head of the independent prosecution. Is there a danger of compromising that position and really there being a conflict of interest in what the former Lord Advocate has said is absolutely essential, and that's that the Lord Advocate gives judgments that are fair, balanced and appropriate?
I'm absolutely satisfied that there is neither a conflict of interest in those roles, nor is there any compromise in the integrity with which those roles can be fulfilled.
Okay. Well, following on from Maureen Watt's line of questioning, did you give any legal advice regarding the judicial review?
Sorry, I didn't quite catch.
Did you give any legal advice regarding the judicial review?
Well, I've made clear the Law Officer Convention, which precludes me from disclosing the involvement or non-involvement of law officers, but that in no sense prevents me from answering any questions that the committee may have about the government's legal position from time to time, the process of the judicial review, the decision-making in relation to the judicial review, or indeed the various considerations that were brought into play at various points in the judicial review. So I'm very happy to answer the questions of the committee on all those matters.
Well, I'm asking you, did you give any legal advice regarding the judicial review?
Well, I'm not sure I can add to the answer that I've just given to the member.
So is that a refusal to answer, Lord Advocate?
Not at all. I'm explaining why I can't, consistent with the constitutional and legal arrangements that apply to all ministers who appear before committees, the particularities of the question that's been asked.
It's a very general question, Lord Advocate. Either you gave some legal advice or you didn't.
I will answer all the committee's questions in relation to the government's legal position, the procedures that were followed, the legal considerations that were brought into play in relation to the government's handling of the judicial review. It wouldn't be consistent with the approach that ministers take to any appearance before a committee or any debate in Parliament to discuss the involvement or non-involvement of law officers. That's a well-established convention respected by all governments in the United Kingdom of all parties and has been respected over a long period of time for very good constitutional reasons.
Well, the problem is, Lord Advocate, that you're refusing to ask one very basic question, and therefore I will move on.
No, Ms Mitchell, can I say that I know that the Lord Advocate is more than capable of answering for himself, but I am aware of the time and many other committee members having questions to ask. So if we could accept that position and move on.
Right. If I can ask specifically about the offer of arbitration from the former First Minister on the dispute over competency and legality of the procedure. Were you aware of this offer of arbitration?
Again, I'm not going to get into my own involvement or non-involvement in any particular issue, but I'm perfectly happy to answer substantive questions in relation to the decision not to take up the proposal for arbitration.
Would you explain that then, Lord Advocate? That might help us.
Indeed, and perhaps I can make this point that as a general rule, where an allegation is made that the government has made a decision which is not valid because it's in breach of some public law rule, that is, generally speaking, not an issue which it is appropriate to submit to a private arbitration. A government decision ordinarily stands until it's set aside, and the only body that can ordinarily set aside a government decision is our court. So it would be unusual. It would be unusual, to say the least, to submit a public law challenge to a private arbitration.
Can I ask, though, would that arbitration have settled the question on competency and legality of the procedure?
Well, it's perhaps important to appreciate that an arbitration involves submitting a legal dispute to as it were, a private judge appointed by the parties. So one has to identify an individual who's got the qualifications and authority to determine the particular dispute in issue. Ordinarily, it's a matter for the public courts, who are authoritatively decide legal questions.
With respect, could you answer the question, Lord Advocate? Would it have addressed legality and confidentiality?
Lord Advocate was answering the question, having been already cut off in answering his previous one. So perhaps it's just my particular interest in this question, but I would like to hear the explanation of arbitration and how it works. An arbitration involves two parties deciding to submit a dispute to a privately appointed judge. In many contexts, there are advantages to arbitration. In other contexts, it's either not appropriate or, for a whole variety of reasons, not the right thing to do. I suppose the first thing to say is there is no reason, and as I understand, there was no reason in this case to believe that arbitration would be quicker or cheaper. Frankly, the judicial review proceeded from a petition at the end of August to an expected first hearing in January. That in terms of a legal process, perhaps regrettably, is pretty swift. And of course, if you go to arbitration, you have to pay for your judge as well as all the other costs associated. As Mr. Coquette observed, there were questions about whether it would be appropriate to resolve an issue of the kind that was at the heart of this by a confidential procedure, because that's one of the key benefits that parties may see in an arbitration generally, is that it's confidential. Now, given the nature of the dispute here, which was whether the government had gone wrong in law in relation to its handling of the harassment complaints, to put it no higher, very serious questions would arise as to whether that was something that should be dealt with by a private procedure. An arbitration may simply give rise to further legal issues, so may not necessarily result in finality, although our arbitration laws are designed to try and secure finality. It's also important where you have a procedure laid down in advance, as there was here for the dealing with harassment complaints. One has to be careful about, as it were, moving off that, departing from that. And the government believed at that stage that it would be difficult to separate out issues of process from issues relating to the underlying complaint. So a set of questions about whether it would truly achieve finality, whether it would in fact be quicker or cheaper, whether it would be possible to separate out the legal issues. And overlying that, from my perspective, is a real question as to the appropriateness and of submitting a public law question, submitting questions about whether a government decision has breached the public law constraints that apply to government decision making to a private process rather than to the courts, whose job it is authoritatively to determine issues of law, and in particular whose job it is to supervise through judicial review process the actings of the government.
Yeah, it's my understanding that arbitration would have sorted out the competency and legality of the procedure. And we're not talking about the substance of complaints, but more crucially, can you confirm what weight the government gave to the fact that arbitration is a confidential process which would have enabled the existence of the complaints and the media speculation about the complainers, which has been so damaging and so distressing to them, to have remained confidential, and for the arguments about legality of the procedure or revived procedure to have been heard in full in private. And that would not have stopped the trial that continued and the substance of the complaints being progressing as they inevitably did.
Well, as I said a moment ago, there are, I think, it seems to me, real questions about whether a public law dispute of this sort can appropriately be submitted to arbitration. It's the job of the public courts which to exercise a supervisory jurisdiction over the decision-making processes of government. And ordinarily, those sorts of questions are ones which are appropriate for the courts and not for private processes, where government ultimately is held to account publicly for what it's done.
Okay, thank you.
Alex Cole-Hamilton.
Good morning, Lord Advocate. Just very brief supplementary on Margaret Mitchell's last line of questioning, and then I'll go on to my substantive points. So just for clarity, are you saying that there was, if the government had decided to take the route of arbitration, that wouldn't have then necessarily ended satisfactorily? It perhaps would have led to a judicial review in any case, or could it have resolved things so that, as Margaret Mitchell pointed out, that it was dealt with quietly so that the whole process could have been restarted and these complaints given fair hearing under a lawful process?
Well, I suppose the question, and of course, none of us can rewrite history, but none of us can know how things would have unfolded. But I suppose the question one might ask is whether, as it were, going into a decision about whether this was a matter that could and should appropriately be dealt with by arbitration, one could have confidence that it would draw a line one way or another. One way or another, the arbitration, of course, at the point where a decision is being made, the government, in June 2018, government would, going into that and contemplating that it would be successful in the arbitration, let's suppose that outcome, would that draw a line under subsequent legal disputes? That's a question that I think one could legitimately have in mind when deciding whether or not an arbitration would actually draw a line under this particular matter, or whether it might well turn out to be the first in a series of issues.
Thank you. So I'd like to explore the roles that you've already defined to a certain degree in some of your previous answers. So you are both simultaneously the independent head of the prosecution service in Scotland, and you're the Scottish Government's senior lawyer. So I want to explore how that works in the context of the issues that we're discussing and exploring in this committee. Some of the detail of who said what to whom, which may be of relevance to our work, is material seized by the police and was only held by Mr. Salmond because it was disclosed by the Crown for use in his trial. And is it right that you have warned Mr. Salmond not to reveal this to the committee?
I think the committee's seen correspondence between Crown Office and Procurator Fiscal Service and Mr. Salmond's lawyers.
Okay. So that's in the affirmative, that.
Well,
because you head up that.
You've perhaps personalised it to me.
Okay, but at your direction.
The Crown Office and Procurator Fiscal Service has corresponded with Mr. Salmond's lawyers, and Yeah.
So you had access to that information, the correspondence or whatever text messages, as head of the prosecution service in Scotland, and that would have informed your decision to prosecute Mr. Salmond, is that right?
Well, I think it's a matter of public record that, as is the case in the great majority of cases that the Crown deals with, neither the Solicitor General for Scotland nor I were personally involved in any part of the Crown's consideration of Mr. Salmond's case. That was conducted by professional prosecutors within Crown Office and Procurator Fiscal Service and a senior advocate depute, as is entirely normal with the most significant and serious crimes that we prosecute.
But you would have been across the detail. You would have had access to that information prior to the trial.
No.
Okay.
As I've said, neither the Solicitor General for Scotland nor I were personally involved in any part of the Crown's consideration.
But you
and that's, as I say, entirely normal. You know, while cases may be brought to us, you know, the great majority of the very significant and serious caseload that the Crown carries is not dealt with personally by law officers.
But you've intimated that you do have knowledge of the material that is held by Mr. Salmond in respect of the work of this committee and why he shouldn't disclose it to this committee.
I personally don't.
You don't? Okay, that's fine. So moving on then, I would like to ask, just in terms of the ongoing dispute about the legal advice, John Swinney wrote to this committee on Friday last week and suggested that the government were considering the implications of the motion passed by Parliament, but that it would, under the ministerial code, require exceptional circumstances, which I think we've reached that test, and the permission of law officers. And I presume he meant you in that regard, is that right?
Well, there are two law officers, as myself and the Solicitor General for Scotland.
Yeah, absolutely. So might it come down to a circumstance where you and or the Solicitor General were the only barrier to the will of Parliament, or is Mr. Swinney trying to use you as a human shield?
The Ministerial Code sets out the procedure that requires to be followed by ministers in reaching a decision, and you know, it speaks for itself.
Understood. Okay, so on the 11th of September...
Yeah, I should say, you know, I think all that Mr. Swinney is doing in his letter is describing what the process is.
Okay, thank you for the clarification. On the 11th of September 2018, the Scottish Government met with Council, presumably to decide whether it would contest the petition, the permission being granted to proceed with the judicial review.
Sorry, can you just remind me of the date you had?
The date I have is the 11th of September 2018. It's in the timeline of events that we've been provided by clerks. It's a meeting. I don't have the reference to the meeting in particular, but that was roughly the time at which the court was deciding whether it would grant permission for the judicial review to proceed. Without going into this case, and you made it very clear why the Law Convention stops you, what are the reasons that Council would suggest not contesting permission to proceed with a judicial review against the government generally? What are the kinds of things it would come up with?
In any judicial review, the first question is whether or not, for a respondent, public authority responding to judicial review, the first question is, should you contest permission? And essentially that the question at that stage will involve a consideration of the nature of the case, the test that has to be met before the court grants permission, and whether and so I suppose question one is, you know, is that test, which is a relatively low hurdle, it's deliberately set at a level that is intended to allow seriously arguable cases to proceed rather than to stop cases proceeding. So is that relatively low hurdle met in this case? And then there are also considerations that may come into play in particular cases about whether it's appropriate to resist permission, or whether it's an issue that the government recognises ought properly to be aired fully in court. I may say, in terms of the specifics of what happened at any particular meeting, I can't help the committee, but I can say that at that stage of the case, the government was addressing a number of issues. Those included whether or not the government should contest permission, a question about who was the appropriate respondent, was that an issue that needed to be aired or not, and also how to deal with the potential for prejudice to the criminal investigation, which by that point was underway. And on the last point, the government considered, and I think this was a point that was raised with Mr. Kekette, the government considered whether or not it would be appropriate for the petition to be sisted, or whether the public interest in relation to the ongoing criminal investigation could be adequately protected by reporting restrictions. And the government on that issue took the view that the public interest could be adequately protected by reporting restrictions, and ultimately that was a matter of agreement. So a number of issues were being addressed at that very preliminary stage, one of which was the question of whether or not to contest permission.
And we know that courts will only grant permission for a judicial review to proceed if it believes that that application has real prospects of success. So we come back to the legal advice. I'm not asking for the content of the legal advice, but we understand now that legal advice is never absolute. It's the balance of probabilities. So given that permission was granted, did that not perhaps give pause for thought at how the government's assessment of the chance of success was?
No, because, as I've said, the real prospects of success test has been interpreted in case law to make clear that it's not intended to be as it were, a significant hurdle to a case which is properly arguable. So all that the court is doing at that stage is saying that the petition passes that threshold. That doesn't mean that, as I say, that's intended to be a hurdle that allows properly arguable cases to go forward. It doesn't reflect on the ultimate merits of the case.
Okay, that's it for now, Convener, but I might have a couple of small follow-ups later.
Okay, I'll bring in Angela Constance at this point.
Thank you very much, Convener. I've just got a few quick supplementaries following what we've heard this morning that I hope the Lord Advocate can answer. Now, we know that governments rarely confirm or disclose their legal advice, but when the Scottish Government has chosen to do so in the past, how have they done that? Not why, but how. So, for example, have they published the advice online, or have they released paper copies? Have they released it generally, or have they released it to named individuals, or have they, locked someone in a cupboard at St Andrew's House with, the one and only paper copy? How have you done this? How have you done this in the past?
In terms of the physical transfer of material, I'm afraid I can't help. But in terms of the particular examples, the committee is aware there are 3 statutory inquiries to which legal advice has been released: the child abuse inquiry, the infected blood inquiry, and the trans inquiry. The information is passed to the inquiry itself, and then it's dealt with in accordance with the rules and regime that applies to statutory public inquiries. There's perhaps one point I might make about the trams inquiry, which is that, as I understand it, the advice was the legal professional privilege was not, as it were, waived generally, but the material was passed to the trams inquiry under reservation of the privilege, but on the basis that the chair of the inquiry would determine whether or not particular matters were covered by privilege or not. That's something perhaps I can follow up in writing with the committee just for absolute clarity. And there were also there have also been, in relation to the other inquiries, certain exceptions, particularly for litigation files. So again, that's something that, if the inquiry is interested, I can have followed up.
I think that would be very helpful, Lord Advocate, if you could confirm in writing how information was released to the in-care survivors of childhood sexual abuse, the trams inquiry and the infected blood inquiry. But if I can just, in terms of here and now, confirm that I've understood you correctly, that in terms of when government decides to release information, as they've done in the past, that they have options around how to do that?
Well, I think the difficulty is that once you've waived privilege, you've waived privilege. The context in which it's been done has been the context of particular inquiries which operate according to a particular set of rules and within the context of a particular statutory regime.
I understand that, but correct me if I'm wrong. I think I heard you say that with one of the previous inquiries, perhaps you'd said it was an infected blood inquiry, where information was released to the chair of that inquiry.
Well, it's the trams inquiry, and in effect, as I understand it, the material was transferred, but on the basis that the chair, who of course is a distinguished former judge, would adjudicate in effect upon whether matters were privileged and on the question of, therefore, of onward disclosure.
Okay, thank you. Well, we obviously have a distinguished parliamentarian as our chair, Lord Advocate.
Yes,
but I just have one very quick final question, Convener. Again, just for clarity, slightly different topic. Can the Lord Advocate confirm whether there was written advice received from Council, including if and when written opinions on the prospect of success of the judicial review were received? Is that something you can answer?
I can certainly say that written advice was received at various stages throughout the process. And there's perhaps an important point to make about, as it were, the legal advice, which is the legal advice is not a single thing at a single point in time. Advice in the context, particularly of a seriously fought litigation, is an ongoing process. And of course, as the committee will appreciate, different lawyers may take different views. The same lawyer may take a different view from time to time as their consideration of the case develops. So that's all part of the normal process of taking advice, and ultimately government has to reach a decision, reach a position, a legal position on which it's prepared to stand and defend itself in front of the court. And throughout this case, that process continued of advice being taken, advice being considered, lawyers expressing views, lawyers refining their views. You'll appreciate I'm not going to go into the detail of that, because the government doesn't waive its legal professional privilege. And advice, of course, may also come in many different forms. It may come in a written form, in a formal document. It may come in an exchange of emails. It may come verbally at a meeting. And that process of development of a legal position may involve, may in any given case involve all of those features.
We imagine that, lawyers changing their mind or disagreeing with each other. Thank you, Convener.
Of course, committee members never do they? We go on now, please, to Alison Johnson.
Thank you. Good morning, Lord Advocate. In a letter the committee received from the Deputy First Minister on the 13th of November, he wrote, as the Lord Advocate has noted, the protection of the government's legal professional privilege is a routine part of good government. But as you've just discussed with Angela Constance, there have been 3 instances at least where protected advice has been shared. Did that mean that good governance wasn't applied in those instances?
The basic point is that it's routinely, government routinely maintains its legal professional privilege in, one might say, point to those examples as demonstrating just how unusual it is for government to waive its privilege, and also that it has done so only in very particular contexts involving statutory inquiries of the sort we've described, and in relation to which there's a particular regime that operates. So I think one might say it's absolutely, for all the reasons I discussed when I was here in September, it's an absolute, it's an important feature of the maintenance of good governance, and its waiver is exceptionally rare.
Okay, but also in the Deputy First Minister's letter of the 13th of November, he says the written submissions from the Scottish Government of 20th July and from Lord Advocate of the 4th of August and my letter of the 14th of August set out the basis on which LPP applies and its importance to upholding the law. And I think it's fair to say this committee has discussed this at some length. But it obviously is possible for legal advice to be shared. And you've spoken about the particular, those particular statutory inquiries, but this is a very particular inquiry as well. And I think it could be, Parliament has set up an inquiry, and it's obviously very difficult, if not impossible, for us to carry out our remit without the sharing of that advice. Is it your view that this committee can properly carry out its remit without such a waiver?
Can I perhaps it's very important, I'll answer that in just a moment. I think it's important I don't say anything that preempts the government's reconsideration of the question of legal professional privilege. I mean, I wouldn't want my agreement that it's an important feature of good governance and waived exceptionally to be taken as a preempting of the position one way or the other. The government is going through a process of looking again at the question, and it's not for me here to prejudge or preempt that, as I say, one way or the other. I'm here to answer in as much detail as the committee wishes to ask me questions about the government's legal position, the way that it dealt with the judicial review, why it took decisions that it took at particular times, and the government's legal position is patent in the pleadings, and for my part, I'm content that I can be as open as can be in dealing with the government's legal position and the considerations that came to bear on decision making at different points in the process. And all of that can be explained and explored without needing to see the, as it were, the blow-by-blow internal thinking about who said what to whom and which lawyer took which particular view. It's a really important point that advice is only advice, and ultimately government has to. The only certainty in a litigation is the decision that the court ultimately gives you at the end of a case, and government has to determine what position it takes in a litigation, and the position that it's prepared to defend in court, and ultimately it's accountable in the court for that position, or it may be accountable in other forums, and this is a forum in which the government is clearly accountable for the decisions that it took in relation to this judicial review.
I mean, obviously this was a very expensive judicial review for the public purse, and on receipt of the petition was an assessment made as to whether the former First Minister had a real prospect of success, and what documentation and material was used to inform that view?
When the petition was received, the government assessed the grounds in the petition. I should say it's entirely routine in a judicial review that government, or any respondent, focuses on the allegations that are made. And at that stage, the government was focused primarily, but not exclusively, on the grounds in the judicial review. It was satisfied that it had a good basis, a solid basis for defending all those grounds, and that it should do so.
Okay, so did the Scottish Government consider that the former First Minister's argument that the procedure was procedurally unfair had a real prospect of success? I'd like to understand if a complete analysis of the policy and how it had been applied in the circumstances was undertaken, in particular the application of paragraph 10. Because paragraph 10 suggests that the person appointed as the investigating officer will have had no prior involvement with any aspect of the matter raised. But in a note from, I think it was James Hind, on the 2nd of November, he suggests the operation of this part of the procedure is not meant to preclude an investigating officer being appointed who had some foreknowledge of the circumstances of the complaint. Those two things, to my mind, seem at odds.
Can I say it's very important to not get the, as it were, telescope the sequence of events. I'll come to clause 10 in a moment, if I may, but it's very important to understand that litigation is this litigation developed sequentially. The petition, as it was first raised, said nothing about the role of the investigating officer and contact with the complainers. That was not one of the grounds on which the petition was raised. Government at that stage was focused primarily on the issues that were identified in the petition, and that's entirely normal in any judicial review. At the end of October, the government identified the issue relating to contact between the investigating officer and the complainer, and the government, having recognised that was an issue that should be addressed, had to do two things. First of all, it had to consider the interpretation of the procedure, and I'll come back to that in a moment. And secondly, it had to investigate the factual position. What was the nature of the contact? To what extent might it be regarded as creating a difficulty? And if one looks at the timeline, through November, both parties were adjusting their pleadings on that issue. And I may say government made factual averments on the 5th of November about that contact and voluntarily disclosed documents to the petitioner because the government recognised that it had an obligation and a responsibility to be candid about the position. And the petitioner then, in mid-November, added that as a new ground, what was a new ground of challenge in the judicial review. And the process of adjustment of the pleadings continued, I think, into December. The government then reviewed its legal position and considered whether, and again, that's entirely normal in any litigation process, that you undertake a process of investigation and consideration, and you then review where you stand. And that process of adjustment of the pleadings having completed in early December, the government reviewed where it stood, and at that stage was satisfied that it continued to be proper to defend the judicial review on the new ground that had been stated, and the issue could and should be put before the court for determination. Now that obviously changed a few weeks later as a result of the documents disclosed in the commission process. But it's very important I think, to appreciate that when an issue is raised in the context of a litigation, it is very, very rarely is it a kind of binary point. Almost inevitably, almost invariably, it's a matter that needs to be considered, investigated. If there are facts that need to be explored, then the facts need to be bottomed out so far as you can before you reach a conclusion. On the specific point about the interpretation of the procedure, I think paragraph 10 of the procedure says this of the investigating officer: that person will have had no prior involvement with any aspect of the matter being raised. And the critical phrase in that sentence is the matter being raised. The government's interpretation of that phrase was and is that it refers to the subject matter of the complaints, i.e. the events which are being complained of. And that interpretation is eminently supportable. It's a natural reading of the words, and the context, as I understand it, is of an employment grievance procedure, which is a context where a manager who's involved in investigating a matter, it's not unusual for there to have been contact with a complainer, and that doesn't on its own necessarily give rise to an issue in relation to the process. So on the government's interpretation of that particular sentence in the procedure, the fact that there had been contact between the investigating officer and the complainer did not itself amount to any breach of the procedure. Now that was the government's interpretation of the procedure, and during the judicial review, it became evident, and this is not, again, particularly unusual in the context of a litigation. One has to revisit one's legal analysis. It became evident that the procedure was capable of being read in a different way, that if you focus on the words any aspect of, rather than on the words matter being raised, that one could read it in a broader sense that would be would mean that contact with the complainers by the investigating officer would itself be a problem in terms of the procedure. But the government's position was, and the government was perfectly happy to put this issue of interpretation before the court for determination, was that the critical wording is, what does the matter being raised mean? And on a natural reading of those words, it's about the matter which is being raised in the complaint, i.e. the subject matter of the complaint. And on that view, the investigating officer who as I understand it, was I think I'm right, wasn't in the Scottish Government at the time of the events that were being complained about, was, as it were, unproblematic in terms of the procedure. So in terms of the interpretation of the procedure, the government was entirely content that there was clearly an issue of interpretation, but that it was entirely content to argue its interpretation before the court and to have the court adjudicate on that question. It's precisely the kind of thing that courts do day and daily, is decide disputed questions of interpretation. There was, of course, a separate argument being advanced, which was that the nature and extent of the contact between the investigating officer and the complainers was such as to justify a conclusion that the fairness of the procedure was compromised by apparent bias. And whether that was right, wrong, defensible, not defensible, depended critically on an understanding of the factual detail of that interaction and of that contact. And as I said, through November, government was identifying documents which helped to disclose the nature of that contact, was otherwise investigating the nature of that contact, was disclosing documents to the petitioner, and having engaged in that process, and both parties having set out their stall, as it were, in the pleadings, reviewed where government stood in early December. And on the factual information then available in early December, the first or second week of December, the government was content that it could properly defend the apparent bias argument. Now, events then move forward and we come to the Commission, and two documents are disclosed which disclose additional contact between the investigating officer and the complainers, which hadn't previously been factored into the consideration, and that led, as is entirely appropriate, to a review of the government's position and ultimately to the concession of the case.
I don't want to take up any more time, Convener, but it just seems to me that paragraph 10 says that person will have had no prior involvement, and you've highlighted it yourself, with any aspect of, and the complainant and the investigating officer have had contact. So it feels like a very risky thing to me for the government to feel that it had a robust ground on which to contest that.
Well, all I can do is to say that the government interpreted that sentence in the way I've described. The language, I have no difficulty with reading the phrase "the matter being raised" as squarely directed to in effect, the subject matter of the complaint. And I'm advised that it's entirely in the context of a grievance process in an employment setting, that the fact that someone involved in the investigation and decision-making in a grievance process has had prior contact with the person raising the grievance wouldn't ordinarily be regarded as giving rise to, in itself, to any issue of procedural unfairness. And because one reads any legal document in its context, that's part of the context in which you read the you read the sentence, and in particular part of the context in which you read the phrase "the matter being raised." Now, as I said a moment ago, government, of course, recognised there was another point of view.
Is it the case then, if someone else had been in the room putting that view forward, that a different conclusion might have been reached? If there'd been someone else in the room who said, actually, any aspect of, we have had someone here who has been involved in an aspect of, this would have been flagged up as an issue?
Well, it was recognised when government, when those involved in the litigation appreciated in late as I understand it, in late October, that there had been contact between the investigating officer and the complainers. The issue of the interpretation of paragraph 10 was immediately focused on as a question that needed to be asked and answered. And, although, as far as I understand it, government had up till that point been very clear about what that meant, and it continued to be satisfied that it could properly defend that interpretation. It recognised there was an alternative way of reading that sentence, and that was an issue it would have to be prepared to argue in court, and it was prepared to argue it in court. That's what courts are for. They're there to determine, among other things, the meaning of documents which are disputable. The mere fact that an argument arises in a litigation doesn't mean that you're going to lose the litigation on that ground. It's an argument to be addressed and considered, and the response to it developed, and as I say, fully recognising that there was an argument to be had. Government was prepared to submit that question to a decision by the court.
Thank you.
If government ran away from every difficult argument that raised in the litigation, that would certainly not serve the public interest.
Thank you. Thank you, Convener.
Alistair Allen.
Thank you, Convener. Lord Advocate, you indicated that some of the issues raised by this case meant that submitting them, I think I'm quoting you accurately here, submitting them to private arbitration in any aspect would, in your view, I think you said, have raised questions given the accountability of government to public courts for their actions. Can you elaborate on what you meant by that?
Yes, it's 2 points. There's a technical point, and I have to confess I'm not coming here expressing any sort of concluded or final view, but as a general proposition, when one's dealing with judicial review type challenges, those are issues that it's proper for those to be determined by a court, and it seems to me at least to be doubtful whether a private arbitration can resolve those issues. There's quite separately, and you've alluded to it in your question, there is separately an issue of accountability. Government, part of the process of accountability of government is that it's accountable for the lawfulness of what it does before the public courts, and that if there is a serious challenge to the lawfulness of government action, then the right place for that to be resolved is in the public courts, and government stands or falls by the outcome, and that's all part of a proper constitutional democracy. And of course, government is also accountable for what it does here in this building, and that's the other strand of accountability. Had this matter gone to a private arbitration and been dealt with confidentially, not for me to comment on how that would be viewed, but there might be questions raised about the government seeking to avoid the public scrutiny that comes from a formal court process.
Thank you. In that case, can I ask, do you think if the government had gone down that line, again, I can see you're not keen to speculate about that what if, but if the government had gone down that line and, as I think Mr Cole-Hamilton said just now, the matter had been dealt with quietly, would it have been possible to have separated those two issues out in a way that would have avoided the controversies of the kind you're mentioning there? Or?
Again, I think it's very difficult to address a sort of hypothetical. The fact is a decision was made not to proceed to arbitration. I think there were clearly questions as to whether an arbitration would truly achieve finality. There were, as I've said, other reasons why an arbitration was considered not the right way to go.
On another subject, without asking about your own involvement or otherwise in this case, because I don't think I'm going to get an answer on that, can I ask if you can explain whether the Lord Advocate would typically be involved in the process of taking decisions about whether or not to oppose commission in the case of a judicial review?
To oppose a commission? I don't think one can answer that in any general way. A commission in diligence, while it's pretty unusual in a judicial review, is not a particularly unusual feature of litigation, looking generally. In fact, it's a normal process of many litigations that the court approves a specification of documents and approves, authorises a commission. And, often that in itself results in the disclosure of documents and no commission is held, but it's not unusual for a commission to be held. The committee will appreciate, if I put it this way, that the law officers have a wide range of responsibilities, and the question of whether a particular decision in a litigation engages or demands the attention of a law officer, as opposed to dealing with one or other of the many other things that may require the attention of a law officer at any given moment, is obviously something that one can't answer in the abstract.
Finally, Convener, you mentioned the Lord Advocate, you mentioned the Law Officer Convention and the Convention about not commenting on whether legal advice was given. You indicated, or you seem to indicate, a distinction in your view between the issues raised between the legal advice around something like an inquiry, such as the Edinburgh trams. And am I right in saying you seem to be drawing a distinction between that in terms of the consequences for future governments on the issues around advice on litigation? Is that a distinction that you were making, or am I reading too much into that?
I think what I would say is that the starting point is government doesn't weigh privilege. It's exceptionally rare. It looks at the particular circumstances and context of when the issue is raised. It obviously looks at the particular circumstance and context, and it has to weigh up the range of public interest factors. And as I said earlier, I'm very keen not in anything I say to be thought to be preempting the process government is undergoing, of looking again at whether it, at how that balance should be struck. There are a particular set of issues that arise in relation to litigation, and I mentioned this, I think, when I appeared in September, because the nature of litigation is that the government's previous legal position inevitably comes under scrutiny. An issue is being raised as to whether the government got the law right previously. Inevitably, that may involve the government having to reconsider whether it was right in the approach it took. It may, as I described in relation to the interpretation of paragraph 10, it may have to recognise that there's a serious argument to be had that it didn't appreciate that it needed to have. And the nature of advice in the context of litigation is an assessment of risks and uncertainties, the taking of advice, which of course is ultimately, it's advice. The only certainty is the certainty that the court gives you at the end of the day if the case runs that far. And there are judgments to be made, both in terms of assessing the merits of particular arguments, and there are judgments to be made about the consequences of that assessment for how one should conduct the litigation. Litigation is a highly dynamic, by its nature, uncertain process, heavily informed by the legal considerations, and one in which it's particularly, it may be thought to be particularly important, government can take views candidly, that alternative views can be expressed candidly, that a debate can be had about what the correct judgment is, and what, as a result, what position the government should take in the litigation. So there is a particular focus in litigation which is maybe thought to be relevant to the public interest considerations. But as I say, I'm very keen, you know, I wouldn't want the committee to think that that is in any sense preempting or prejudging the way the government will approach the issue, which it's looking at again at this stage.
Thank you, Convener.
Jackie Bailey.
Thank you very much, Convener, and good morning, Lord Advocate. It still is just about the morning. I have a number of questions, so I'm very content with short answers, and I will try and be as quick as I can. Firstly, can I ask you, we obviously understand the process outlined by the Deputy First Minister in following the parliamentary vote, but can I ask you, have you received a request from the Deputy First Minister, or indeed from anybody in the Cabinet, in relation to the release of legal advice following the vote in Parliament?
I don't think it would be right for me to either preempt or
I'm not
or
asking
add.
you to do that. It's a process question, and I was very clear that I can't ask you about the content, and I absolutely will abide by that. But it's the process, and I'm keen to understand in the process, have you yet been contacted by the Deputy First Minister?
Again, I don't think it'd be right for me to discuss what is an ongoing process that government's engaged in, and which ultimately will result in a collective decision by ministers.
Sure, but it's not the collective decision by ministers that I'm asking about. That's very clear in the Ministerial Code, but they do need to consult you, not as a minister, but in your role as Lord Advocate. I am merely asking a process question about, have they actually consulted you yet? Have they, picked up the phone, dropped you an email, chapped the door, gone on Zoom, anything? Have they been in touch with you about this?
Well, you say I'm consulted as Lord Advocate. The law officers required to be consulted. They are being consulted in their capacity as the government's principal legal advisors in the context of that process. So I'd want to, I don't think it'd be right to get into the way in which that process is being taken forward at the moment. The Deputy First Minister set out what the government is doing.
Indeed, and you referred to the process, which is why I'm asking the question.
Yes.
In terms of the I'm not asking you for the content, I'm not asking you for the deliberations. I'm simply asking you, has anybody contacted you about this yet?
Well, I mean, I'm clearly aware of the process that's
that wasn't
ongoing.
my question. I know you're aware of it because you're a smart man. My question is very specific. Has anybody contacted you yet?
Indeed, and I don't think it would be consistent with the collective nature of the decision-making process for me to, at this stage, when it's an ongoing process, to get into the ins and outs of internal discussions.
I'm not asking you to get into the ins and outs, but I accept, I've tried several times with you, Lord Advocate, to get an answer, so I'm not going to pursue that further. But I wasn't asking for the ins and outs. I was asking for one very specific thing. Okay, can I take us to the process of the commission of documents, because I'm interested in that. You told us previously that information emerged in, I think it was late December 2018, which made the government's case impossible to sustain. What exactly was that information that you were referring to?
What happened in the, and I'm not, I'm not sure if I used quite that phrase, but in any event, what happened in the commission was the production of two documents. And I think the committee has those as JR 011 and JR 017. Those documents disclosed additional contact between the investigating officer and the complainants, which had not previously been appreciated. the letter, the JR 011, was a letter which referred to a meeting between the investigating officer and the complainer, one of the complainers, on the previous day, in effect immediately before the formal complaint was made. And the other was an email chain which indicated arrangements to meet between the investigating officer and the other complainer.
Okay.
And then on the 21st of December, the investigating officer gave evidence at the commission to the effect that she couldn't recall the meeting referred to in JR 011. Disclosure of that material was damaging in a number of respects. First of all, it revealed, apparently revealed, direct contact between the investigating officer and the complainers immediately, or at least one of the complainers immediately before the formal complaint was made, and that altered the whole factual picture which government had when considering the question of not actual bias, because I don't think there's no suggestion of any actual bias here, but of whether the objective test for apparent bias was met. And government clearly had to review that question. And that picture of additional contact, one might say, called for explanation. Government was unable to explain that because the meeting couldn't be recalled. So government was not in a position to rebut what one might, the inferences that might be drawn. And there may be just a couple of, sorry,
okay, I know, it's just, I've got a lot of questions to run through, and right. I'm conscious. I'm
just trying to explain why the revelation of those documents was damaging.
I understand that.
It's perhaps just worth making this point. It was obviously substantively damaging from the government's perspective, and properly prompted our review of the whole factual picture. It's also the reference to a meeting apparently to a meeting between the IO and one of the complainers on the day before the complaint was formalised, contradicted a statement the government had made in its pleadings. And the emergence of these documents at that very late stage also contradicted assurances which counsel had given to the court and their counterparts about the disclosure of documents. So, there was, as it were, an impact on the government's presentation of the case as a whole. But the critical point was that, as a result of all of that, a review was prompted to factor those additional facts into the whole factual picture, and the government concluded that it was no longer proper to defend the apparent bias allegation.
Can I take you back? Because the government opposed the Commission documents on December the 14th. Can I ask why they opposed the establishment of the Commission? Because that was where those documents were revealed.
Absolutely. And I should say that at that stage, government had gone through a process of voluntary disclosure of documents.
Yep. But at that stage, a senior civil servant actually told the court that there were no other documents to disclose.
Well, that's the point that I've just made, that the arrival of these documents, or the discovery of these documents in the course of the commission process, contradicted assurances that had been given.
So if the government had won their position on the 14th of December, we would have never seen these documents. So I'm kind of left wondering whose interest was it to conceal it?
There was never any intention to or desire to conceal anything. In fact, from, as I said earlier, the whole approach the government took in November in terms of putting facts into the pleadings and disclosing documents voluntarily reflected a desire to be candid and transparent. Now, regrettably, and we know from the way that matters turned out, the investigations undertaken then to identify all the relevant documents and to get a full picture of the facts was not as robust as it should have been, and lessons have to be learned from that.
I mean, I think you certainly said at your last appearance in the committee on the 8th of September to, I think it was Margaret Mitchell, that there was no decision to withhold documents, no. But why did the government then oppose the motion to establish the commission?
Well, I think I'd have to. I would have to give a. I may have to follow up
okay.
the reasons for that decision in writing. But what I can say is that it's an entirely routine part of the litigation process for a litigant to seek to oppose a formal order for the production of documents inter alia because it's already produced documents or on a variety of other grounds. So that's not unusual for that to be a matter
and I
of
accept that. It's
debate.
just that the government didn't produce all the documents,
well,
clearly.
Well,
know? So can I move us on to, because it's clear from the timeline I have in my head and the evidence we've been given that actually the lack of independence of the investigating officer was known in late October. Okay, given that you're the government's top legal advisor, did you know about that at that stage?
I've already said it wouldn't be right for me to disclose my own involvement or non-involvement in the process. What I can say is that from late October, the government was well aware that that was an issue that required to be addressed.
Okay. Did you at any stage, probably can't answer this either, but let me try. Did you at any stage intervene in the process, particularly around the disclosure of information to the Commission on Documents? Did you email, send memo? Did you pick up the phone to anybody to say, we need to disclose information?
What I can say is that the government was very clear, and this goes back to the initial point where the issue was identified and to the work being done in November, that it required to be candid and transparent. Now, as I say, it proactively put factual averments into the pleadings, it voluntarily disclosed documents. We know from what transpired in December that the process of investigation and identification of documents at that stage was not as robust as it should have been. Okay. And that is, there is no question that lessons have to be learned corporately by government in that regard. Okay. But at no point was there any intention, desire or wish to be anything other than entirely transparent, and ultimately for the government's decision to be determined by, laid before the court fully, as we do in all government litigation, and stand or fall by the decision of a court.
Okay. Can you, as our most senior law officer, confirm now that all documents, whether it's the Documents Commission, whether it's the search warrant in the criminal case, all documents have been released by the Scottish Government?
Well, I'm afraid, and I'm not trying to be at all difficult here, the phrase "all documents" and which documents are we referring to, and to whom are we considering?
If I knew that, directed. This committee would be over much quicker. I don't know that, which is why we're asking it of the Scottish Government.
Perhaps the point that can be made is that government carried out searches in November. It is clear those were not robust enough. Additional documents came to light in the course of the commission, which is not, frankly, and I've been involved in litigation for, nearly 3 decades now. It's not that unusual for documents to be identified in the course of a commission, but it shouldn't happen in a case of this sort, and it shouldn't happen where assurances have been given to others about the position. I think the committee is aware from evidence it's already heard that even after the commission, further documents were being identified. And again, that simply goes to illustrate that the process of seeking to identify all the relevant material in November was not as robust as it should have been.
Can I ask you, we're told that the Permanent Secretary took the decision to concede the case after a report from Sarah Davidson, Ms Davidson told us that she didn't, in fact, meet with any legal advisors. Did you ever see that report?
Again, I don't think it would be right for me to comment on what I've seen or not seen.
Okay. Let me try again in a slightly different way. So, according to the Ministerial Code, ministers may acknowledge that they've received legal advice on a particular topic, but not who provided it or the content. So, did the Permanent Secretary receive legal advice on the case at the time of the Davidson report? I'm not asking for the content. I'm not asking who gave it.
I think that's a question you'd have to ask the Permanent Secretary. My understanding is that the report itself contained legal analysis, and I think the committee's already had some evidence about the matters that were dealt with in the report, and it wouldn't be surprising if the Permanent Secretary sought additional legal advice thereafter.
Okay. So you're not aware whether the Permanent Secretary did or didn't seek legal advice?
I don't. As I say, I think it's a question would be better asked of the Permanent Secretary.
I know, but you're here.
Because, well, I'm very conscious I'm here, but in the sense that I'm not directly party to what she did and didn't do,
so
I'm not.
Let me ask you. Let me try in the same vein. Okay, in the same vein, did the Permanent Secretary or ministers receive written legal advice after the issue emerged in late October about the activities of the investigating officer?
There were, well, as I said earlier, advice is a process, and there was written advice, both internal and external, as I think I would be right in saying there were, of course, meetings at which advice may have been given verbally. It's not a, and in the normal course of things, that's all part of the way government comes to a decision about the position that it takes in a litigation.
So in response to Alison Johnson, you certainly gave me the impression that there was a review in December, but actually, based on what you've just told me, there was ongoing legal advice from late October to early December. In
any hard-fought litigation, there will be ongoing legal advice at different stages.
Okay. The names of the two external counsel are already in the public domain. I don't understand why we can't see their written opinions when Parliament has voted for it, and indeed the public paid for it. And you're unable to tell us whether you've had a request following the Parliament vote as to what was happening. So, just so that I understand, when Roddy Dunlop was giving his opinion to you, who did that go to? Was it to you? Was it to the Permanent Secretary? Was it to the First Minister? Was it channelled through you? What was the process of how that arrived?
Well, again, you're describing this as if there's a single piece of legal advice. In fact, advice is being given and received constantly in different ways, and in the ordinary process of government, that's. I don't think there's a sort of simple answer that could be given to that.
Well, let me put the question in a different way then. At key points, Roddy Dunlop would have given his opinion. Usually these opinions from QCs are in writing. On the occasions where they were in writing, who did that opinion go to? Was it the Permanent Secretary? Was it the First Minister? Or was it filtered through you?
Again, I'm not sure that I can give an answer. I certainly can't give an answer here that would that I would be confident would be accurate in terms of what was done in every case.
Okay. It would certainly be the case that you could tell me, in relation to yourself as Lord Advocate, whether these opinions were filtered through you.
Well, as the committee knows, I'm constrained in terms of what I can say about my own involvement at different
which is why
stages.
I'm not asking about content or who gave it. I'm simply asking a process question about the flow of information. That's all I'm asking.
And again, I don't think I can give an answer that I would be confident would be accurate and appropriate, given the range of circumstances in which advice was being tendered and the different ways in which it was being proffered.
Okay.
How many more questions?
One more, Convener,
good.
you'll be pleased to hear.
Yes.
I rattle through my questions. According to the Ministerial Code at paragraph 2.3, it is your job as Lord Advocate to ensure that the government acts lawfully at all times. Clearly, this didn't happen in this case because the government's actions were described as unlawful, procedurally unfair and tainted by apparent bias. With the opportunity to look back, why do you believe that, as some have said to me, that you failed in this most important of tasks?
Well, I suppose that it's quite important by way of general context. I mean, you're absolutely right. That's one of my responsibilities under the Ministerial Code. Government's actions from time to time are tested in court. And from time to time, the judgments that have been made across government about their position, and the minister will, the member will appreciate law officers are at the apex of an enormous system of legal advice. The Ministerial Code makes clear that most advice is tendered by others within the government legal directorate, albeit that law officers are ultimately responsible. And that's a system that's in place to try and ensure, so far as possible, so far as any system can, that legal considerations are properly taken into account in the actings of government. From time to time, the government's actings are challenged in court, and from time to time, it's found to have acted unlawfully in different ways. That's the nature of any human system, that from time to time errors are identified that with hindsight one would certainly always wish had been identified at a different point. That doesn't mean there's been any failure of responsibility in terms of accounting for what's been done. It's part of our constitutional system that government is open to scrutiny in the court, that its decisions are open to challenge, that serious arguments can be raised, and that from time to time government will be found to have acted unlawfully. That's the nature of a constitutional democracy, and it's one that, I, for my part, am very happy to play my part in.
Thank you, Convener. Thank you.
Martin Fraser.
Thank you. Good afternoon, Lord Advocate. We have covered a lot of ground this morning. I just have a few follow-up questions to some of the questions my colleagues have asked, and hopefully to try and just fill in a few of the blanks. And I appreciate the constraints you're under in relation to the legal advice. But can I just start by following up some of the questions that Alison Johnson asked about the issue of paragraph 10 of the procedure? I mean, just to quote this, because it's very relevant, paragraph 10 says this: in the event that a formal complaint of harassment is received against a former minister, the Director of People will designate a senior civil servant as the investigating officer to deal with the issue. That person will have no prior involvement with any aspect of the matter being raised. Now, I mean, this is obviously the issue in which the case fell, and just simply looking at this as an outsider, I would have thought that when it became apparent that the investigating officer did have prior communication with the two complainants, that would be deemed quite quickly to have been fatal to the government's case. But what you've been saying to us suggests that the government took a different interpretation. If I can take you to the timeline on the judicial review that the Scottish Government has supplied us with. There was a meeting held, because you said, just put this into context, you said earlier that you came to understand towards the end of October that there was an issue with this prior engagement of the investigating officer with the complainants. And we also heard that in evidence from Paul Coquette 2 weeks ago. If we look at the timeline, there was a meeting on the 2nd of November, which was a consultation with Council, with Elizabeth Lloyd, who was the First Minister's Chief of Staff, and the Scottish Government to discuss this new material which had emerged. So, first of all, can I ask, were you in attendance at that meeting?
I'm not going to say whether or not I was in attendance at the meeting, but I'm very happy to answer fully the substantive questions that you've raised. I suppose it's first of all important that I make clear that the issue on which the case was conceded was not the interpretation of paragraph 10. It was conceded on the grounds that on the whole factual picture of contact between the investigating officer and the complainers, that the objective test for apparent bias was met. I think that's quite important because, as I said to Alison Johnson, the government was content and continued to be satisfied that the interpretation which it put on that sentence in paragraph 10 of its procedure was an eminently defensible one, and one that it would have been prepared to put before the court for adjudication. So that no concession was or has been made about that question of interpretation. And so when the issue was identified in late October, and of course immediately people went to paragraph 10 of the procedure, that was not considered to be fatal. It was identified that there was a debate to be had, and any lawyer involved in litigation understands that there are many issues that may arise and that one may have to defend and argue in court. But government was content that its interpretation of that sentence was one that was capable of being argued and defended in court, and one that it would be right to submit to the determination of the court. The apparent bias issue, of course, depends ultimately on a close knowledge of the facts, and regrettably, at the point where matters had been investigated in November and things were reviewed in light of that, the full factual picture was not known. There's perhaps another point that is worth just making, which is a concession. The question of whether or not to concede a case is, of course, itself a difficult exercise of judgment. It obviously is informed by a consideration of the legal considerations and the legal position. But I suppose one has to ask, what would a concession have looked like, or what would its effect have been had government conceded this case at a point where it considered that it had properly and responsibly statable arguments? We had two complainers, we had complaints. As long as government had properly and responsible statable arguments, there was a strong interest in putting the matter to the adjudication of a court and having the clarity and certainty that would come from a decision by the court. And I say that partly because of that underlying interest of complaints and complainers that had a determination, apparently, which was under challenge, and the desirability of not conceding that, as long as there was a properly responsible argument to be made. And one also has to remember that this was a case where there was a plethora of grounds of challenge, from challenges to the lawfulness of the procedure itself, to its application to a former minister, all the way through to particular issues in relation to the way it had been applied. A determination by the court assuming, of course, that there could be responsibly defended, a determination by the court would have given clarity and certainty, even if government had lost, about precisely where any error lay, and have given clarity and certainty in terms of going forward. So, I think it may be worth reflecting on the range of considerations and the virtues of, as I said earlier, the government submitting its processes to an adjudication by the public court, whose job it is to tell us ultimately, the only body that can definitively tell us what the law is and how it applies.
Yes, although of course this did not reach the determination by the court. It was conceded by the government. Yeah. Okay.
Indeed.
Okay. Just going back to the meeting on the 2nd of November and the subsequent events. So presumably at that meeting, fresh legal opinion would have been taken from council around these new facts that had emerged, and that would have developed over the coming weeks. Was there any point in this process where the decisions of the government were contrary to the legal advice that was given?
Well, I think I mean, you're absolutely right to say there was, advice has been taken constantly. As part of that process, and it's perhaps quite an important point about legal advice to government, and there's an issue about what do we mean by the legal advice, because advice is coming from a range of sources, external and internal, and ultimately, government has to synthesize that range of advice and take a position. In the course of that process, different lawyers may express different views. That's a normal part of that process, and the same lawyer may at different times express different views. Again, that's a normal part of the process, and it's it was a feature of the process here that different views were expressed, and different, and indeed, the same individual at different points may have expressed different views. That's entirely normal. So, ultimately the question, that's synthesized, and the government reaches our position.
So what you're, if you forgive me for trying to summarize, but what you're saying is there may have been cases where the view of the senior council in this case was not followed by the Scottish Government.
Well, I'm not, you'll appreciate, I'm not going to attribute any particular advice to any particular individual. What I'm describing is a process, which is the normal process of government litigation, or I suspect, the normal process for other parties who are engaged in litigation as well, where there may be different views expressed, and the same person may express different views at different times, and ultimately our position is taken. But government hasn't waived its legal professional privilege. That precise toing and froing is not something I'm going to get into.
Okay. We know that when the award of expenses was made to Mr Salmon, it was done at the highest level, which in the words of Lord Dunlop would only be made where the defence was conducted either unreasonably or incompetently. Now, how would you characterise the defence made by the Scottish Government? Because clearly something went far wrong with it. We know, for example, and it's in the timeline again, on the 18th and 19th of December, that these new documents were produced by an investigating officer in terms of communications between her and the complainants, which had not previously been identified. Was that incompetent?
I think it's Lord Hodge. I think it said Lord Dunlop.
Sorry, Lord
yes,
Hodge.
Lord Hodge.
Too many lawyers getting involved.
And as when I answered a similar question in September, I'm not going to attribute any particular adjective myself to the position. It was highly unsatisfactory, let's put it that way, highly unsatisfactory that the government should be in a position where, having set out its stall in pleadings, having disclosed documents, having given assurances to the court that full disclosure had been made, that what then transpired was the revelation in the course of the commission that there were additional documents not previously disclosed, which, you know, bore substantively on the issues in the case. And indeed, as the committee's heard, further documents were identified even after that point. You know, that was not the way, not the way that I, as the government senior law officer, would like to see a government litigation conducted. And it's very clear that corporately there was a failure in terms of absolutely getting to the bottom of all the documentation at the time when it should have happened, i.e. in the course of November. Now, I don't for a moment, you know, I should say I recognise the difficulties that can be involved in identifying all possible documents in, you know, across, you know, on different devices, identifying documents that may have been deleted, or from some devices and not from others, and so on. I mean, you would have to ask others about the details of recovery of documents, and but I am alive to how challenging that can be in any large, complex organisation. It's not unique to government; it can be challenging for large corporations. But, you know, from the perspective of government litigation, it's not the way I would like to see a government litigation conducted, and the organisation corporately, will learn lessons from that process, both in terms of an appreciation of what is expected of government in terms of drilling into the fine detail of facts where facts are an issue, and also in terms of its document storage, retrieval, and so on.
Okay, so I appreciate you don't want to use the word, but, you know, given what we've said about Lord Hodge and his view on the expenses, if it's either unreasonable or incompetent, it sounds like you're conceding it was incompetent. But I appreciate you might not want to accept that.
I don't think it's. I mean, and indeed, you know, different judges use different adjectives in this context and in others, or different tests. I mean, the point is that the government should not be in a position of having given assurances about full disclosure, and then for those to turn out to be inaccurate. You know, that is not an appropriate outcome from a government point of view, and certainly not from my point of view as the government senior law officer.
Okay, can I just close, if I may, convener, just by asking a couple of questions about the legal advice issue that, you know, a number of colleagues have raised. In the judicial review, there were two responders named. The first named responder was the Permanent Secretary, Leslie Evans, and the second responder was Scottish ministers. Did the two responders take the same legal advice throughout this process?
I think you're right, there were two respondents. They were jointly represented. There was no conflict of interest between them. They were jointly represented throughout the process, both as it were, internally and externally. So, you know, there would be no differentiation between the advice and representation.
Okay, thank you. I appreciate, we all understand, we discussed this morning, why the ministerial code binds the ability of Scottish ministers to release their legal advice. That does not apply to Leslie Evans, does it?
Well, the Permanent Secretary is the Permanent Secretary of the Scottish Government, and that was the capacity in which she was acting, as far as I understand it, throughout this. And that's the basis upon which, throughout this process, there was joint representation. In effect, it's a process and a decision by the government.
But as a point of fact, the Permanent Secretary is not bound by the ministerial code.
Well, to the extent that I suppose any civil servant operates within the framework of government, and government collectively operates within the framework of the ministerial code, I wouldn't accept that.
Okay. Is there any legal impediment to the Scottish Government releasing their legal advice?
Well, the decision whether or not to waive legal professional privilege is one that's available to the holder of the privilege. Government does not, as the committee is well aware, that government ordinarily doesn't, and it operates in deciding on that matter. It operates within the parameters set out in the Ministerial Code, which is, it may not be law, but it's in the sense of justiciable in the court, but it's an important document in terms of setting the constitutional parameters and the constitutional framework within which ministers operate.
Yes, but that's fine. I mean, just so we're clear, this is not a legal restriction. It is a matter of convention. So it is a political choice on the part of ministers to decide whether to release this legal advice.
Well, it's a matter that's governed by the Ministerial Code, and the Code is, as I said a moment ago, an important document in setting out the constitutional framework within which ministers operate.
Okay, and my final question is, perhaps you can just confirm this, that legal privilege rests with the client and not with the lawyer.
Yes, the purpose of privilege is yes, precisely.
Thank you. Thank you, Convener.
Okay. I'm going to allow a quick question from Alex Cole-Hamilton and a very quick question from Margaret Mitchell. Alex Cole-Hamilton.
Very much, Convener. These follow nicely from Murdo. They're two very quick yes or no questions or with a specific answer. Who ultimately was responsible for signing off on the government position on legal advice for that second responder, that being the Scottish ministers?
Sorry.
So Leslie Evans clearly had a driving seat in terms of the government side of the defence, but there were two responders, as we've heard. Scottish ministers with the second. So she wasn't operating with total autonomy, clearly. There must have been her sense-checking the decisions on how to act on the legal advice with somebody senior within Scottish ministers. Was that the First Minister?
The First Minister was certainly involved during the process,
but was she ultimately the final sign-off on decisions taken around the legal advice received by the government?
Well, in terms of the decisions about the position which government should take in litigation, that was...
but she's the top of the government. She's involved.
Well, that was resolved in the normal way in which it's resolved through government, and in this case, the First Minister was the minister who was, as I understand it, directly involved.
Okay, that's very helpful. And final question, and you described to Murdo Fraser in your discussion about the slow discovery of evidence, the fact that government hadn't disclosed everything. That must have been very frustrating for law officers, for government legal counsel, that your client, the Scottish Government, had not given all the evidence at the start. It must have been very embarrassing for senior counsel. Yes, it must have been embarrassing for senior counsel to keep having to go back to court with the disclosure of this information. Very fraught environment, difficult circumstances to work. Did anybody threaten to resign as a result of that tension?
Can I say that against the background where government had determined to be, and was determined, as it ought to be in litigation, to be candid and transparent, to find itself in the position that it found itself in the course of the commission and subsequently in terms of additional documents coming to light was embarrassing.
So did senior counsel threaten to resign?
In the I'm not going to get into advice given by lawyers.
But that's not advice. That's an event.
One thing that I perhaps should say is that one of the issues that may need to be addressed when in the context of any litigation is whether an argument is properly stateable, properly advanceable or not. It often doesn't need to be said, but if counsel on their responsible judgment consider an argument's not properly statable, then the corollary is that council can't, consistent with their responsibility to the court, advance it. And it may happen in the course of any litigation where one gets to that stage that council may have to say, I couldn't advance this argument.
Okay, so and that's not
Mr.
about
Cole
advice.
Hamilton, please.
Okay.
We're well over
Yep.
time. Thank you. Margaret Mitchell, a quick question.
Yeah, very briefly, Lord Advocate. Given it was the Scottish Government's position that the application to proceed with the judicial review was time-barred, why didn't it oppose it?
I think I'd have to check this, but I think if I remember correctly, it was only certain grounds that the government accepted, or government was considered was time barred. And one of the considerations, when one goes to a permission hearing, where there may be, for example, a time bar argument in relation to certain grounds but not others, is whether it's right to seek to resist particular grounds being included on that basis or not. I think I'm right in recalling that it was only particular grounds that were the government wished to argue were time barred. It's also fair to say, if I remember correctly, that your government recognised that there were, that was an argument it was prepared and happy to advance, but that there were serious things that could also be said on the other side. And again, therefore, that was not an issue that that wouldn't be the basis for resisting the petition going forward. It didn't consider that it would see the petition off. Because there were other grounds that were not time-barred.
Yeah, it just seems strange, and it would have been a definitive yes or no, either was or wasn't. Thank you for that. Anything further you can add to that you think you haven't given today in response would be helpful.
Okay. Thank you very much. I do have quick questions, if you don't mind, please, Lord Advocate. It's just I've been, listening to all the evidence and having read so much over the piece, there's a few very basic things that I would like a response to. And one is, the original judicial review was about the efficacy of former ministers being part of it, and that was an unfairness, it was deemed. And it was further down the line that it came in about the investigating officer for all the reasons that we've heard today. Now, when the judgment, I don't know if that's the correct term, decisions were laid down at the end, it was said it was procedurally unfair and tainted by apparent bias. We've always focused on the issue of the investigating officer and Clause 10, which Alison Johnson and Murdo Fraser have raised. Can I have a view on the wider issue of the inclusion of former ministers within an overall policy? Yes. Is that part of the unfairness, or is that something yet to be decided if it is ever again challenged?
It wasn't part of the basis for the concession. Government was satisfied from the outset that ground and all the other grounds that were stated at the outset were eminently defensible and ought to be defended. And I suppose, Convener, the point that you've made about that not having been decided perhaps illustrates the observation I made a few moments ago about the public benefit of a judicial decision. Now, I'm conscious that in this case we didn't get to a judicial decision, but it's a factor, a legitimate factor that government could take into account in deciding whether to continue to defend a case, that there is a substantial benefit in having the clarity that a judicial decision gives, as long as the case is properly and responsibly defensible. And that's why it was only at the point where the government concluded it wouldn't be proper to continue to defend the case that it conceded it. And that, of course, is the responsible and right thing to do.
Okay, and another issue, you yourself a short while ago raised the issue of there having been 2 complaints, and it's too easy to lose sight of that in some of the discussions that we've been having. Now, I know that fairly early on in the process there was an offer of mediation which was rejected, and quite clearly mediation would have involved the complainers. I'm interested to know, further down the line arbitration was offered, which is a very different thing, and you explained it for us earlier. Can I ask what effect, if any, arbitration would have had on the complaints or potentially the complainers?
Well, I suppose if for the sake of argument, let's assume that there had been an arbitration that could competently set aside the government's decision, and let's assume that had been the outcome, then the complainers and the complaints would be in the same position as they are now, or as they would have been had the government run the case to a conclusion and lost the judicial review. And the convener, you're absolutely right that, of course, at the heart of this are complainers and complaints which needed to be determined, and how, on the basis of the concession made for the reasons we've discussed, never been resolved.
Okay. Thank you very much, Lord Advocate, for your evidence today. We have kept you longer than was planned. I don't know if that's your long answers or the fact that it was so very interesting.
If my answers have sometimes been
well,
longer,
we understand they were necessary, and I think we've all found today very, very useful. I took a wee note that there was a couple of things to be followed up in writing. If you do that, it would be very much appreciated. And we'll now have a short break before we move on to the next witness.